Hello everybody, myself Tanvi. I'm here again to teach a new topic of land and real estate. And the name of the new topic is land revenue administration and land acquisition. In my previous video, I have already covered the aspect of land system and there are different three major land systems prevailed in India. The first is Zamindari System, second is Rohitwari, and third is Mahalvari. Uh, I only discussed the effect of peasants, especially on peasants, uh, because of this three land system bifurcation. Now I'm here in this video majorly talking about land revenue administration and land acquisition and constitution principles, constitution provisions related to land. If I will start with the history of land revenue administration, the history of revenue administration had originally been the administration of land only, as taxes from land was the only means of revenue to the sovereign. History of administration of any land starts with the surveying and settlement of land even in the modern era. Land revenue being the only item of revenue in the olden days, either in the form of cash or kind, periodic survey and settlement has been considered one of the prime functions of any government. Origin of cadastral survey and settlement in India is traced back to 985 to 111 AD during the period of Raja Raja Chola I of Tanjore, Tamil Nadu. The first scientific survey and settlement in India is attributed to the period of Mughals during the administration of Raja Tolmal as the finance minister of Akbar the Great in the year 1560. The Raja Tolmal pioneered the Patwari system, which is still practiced in the Indian subcontinent, improved later by the British. As the taxation was purely based on the yield of the crop and not the extent of land cultivated, Raja Tolmal took a careful survey of crop yields and prices of the produce over 10-year period to fix the benchmark for calculation collection of taxes. The measurement unit of measurement was Bika. On this basis, the tax was fixed on each crop to be paid in cash. The entire province was divided into revenue circles for this purpose with different rate of taxes. The survey-based taxation system was followed in Mughal-controlled areas in its letter and spirit till the period of Aurangzeb from 1658 to 1707, but the system failed miserably after that. Um, After the Battle of Buxar, the prime victim, Shah Alam II, signed the Treaty of Allahabad on 1608 1765, which secured Diwani rights for English East India Company to collect and manage the revenue of almost 100 crore acres of real estate, which forms part of modern states of Bengal, Orissa, Bihar, Jharkhand, and Uttar Pradesh. Lord Clive appointed James Rennell as the first Surveyor General of India to have detailed assessment under their jurisdiction. The company started the survey of India in a small way in the year 1767 in the Bengal Presidency. The company failed in the process, and in 1772 the British government took over the function of survey and collecting tax by employing collectors. During the period of Warren Hastings, the administrative machinery for the collection of taxes on land was laid down in a somewhat organized manner. Now, the following flowchart is talking about the uh, chronological uh, chronology of the concept of land revenue and its system. The first prevailed was the major aspect of country, and then jagirdars and jagirs or jagirdars. Then came zamindars. Then came peasants, who majorly included the major part of the sufferers or exploiters or exploitees. During the period of 10 years, like Zamindari, Rohitwari, and Mahalvari system were practiced in British India in Travancore as per the revenue settlement. As per the Revenue Settlement Proclamation of 24th February 1886, for the first time in the history of region, cent and acres were introduced as unit of measurement of area in the survey process, and the type of tenure were fixed as either Sirkar or Poromboke or freehold or gem. Now, as I've already discussed the three type of land system, first is Zamindari. I've already, uh, as I talked about Zamindari, Rohitwari, and Mahalvari system in my previous lecture. I just want to quickly briefly discuss these three land revenue systems which prevailed before India got independence. So, Zamindari system being the first land revenue system introduced by Cornwallis in the year 1793, also known as permanent settlement system, which came into effect especially after the enactment of Permanent Settlement Act, introduced majorly in the provinces of Bengal, Bihar, Odisha, and Varanasi. Zamindars were regarded as owners of land, and zamindars were given rights to collect rent from the peasant. The realized amount would be divided into 11 parts. One out of 11th share belongs to zamindar, and 10 out of 11 of the share belongs to East India Company. So nothing was in the hands of peasant. Royal system, as I've already discussed, introduced by Thomas Munro in the year 1820. Major parts included Madras, Bombay, Assam, parts of Assam, Kurk, provinces of British India. In this particular system, ownership rights were handed over to a peasant, and British government collected taxes directly from peasant. The revenue rates of Royalty were 50% where the lands were dry, and 60% in irrigated land. And the third system of land revenue administration is Mahalvari, introduced by William Bentinck, majorly in the areas of central province, north, west, frontier, Agra, Punjab, Gangetic Valley of British India. Had provision. This is a mixture of both Zamindari and Royatwari system. The land was divided into mahals, and each mahals comprises of one or more villages. Ownership rights were vested with peasant, and village community were held responsible for collection of taxes. Now I am here to discuss the provisions of land and land revenue administration, which are mentioned specially under Indian Constitution. Schedule 7 of Indian Constitution talks about three different lists: a union, state, and concurrent. Under these three lists, there are some items there. It has been mentioned, the aspect of land has been mentioned in different items under union list, item 88, and list under the list. So the union list is divided into different points. 88 talks about duties in respect of succession to property other than agricultural land. Item 18 is talking about land and land tenure, rights over land, including the relation of land lord and tenant, and the collection of rent, transfer and alienation of agricultural land, land improvement and agricultural loans, colonization. Now under state list, item 45 and 49 is talking about land. 45 is talking about land revenue, including assessment and collection of revenue, the maintenance of land records, survey of revenue purposes, record of rights, and alienation of revenues. And item 49 is talking about taxes on land and building. Concurrent list is talking about sixth item, which is transfer of property other than agricultural land and registration of deeds and documentation. So this is kind of a jigsaw puzzle wherein each item is interlinked with the other. Title is related to rights. Title of the land is related to the rights owned by rights either of landlord or of the peasant, and then interest over that particular land, and then tenure of that. All these are, it's a vicious circle. Now, again, this particular diagram is talking about government and private. Government plus private land acquisition is land tenure, which also have a reference to doctrine of eminent domain and public trust, which I will explain in the next video. Conditional freehold in private plus conditional leasehold in private or government is equal to land titles, and the following are the rights of the presumptive title holder. What all rights do presumptive title holder get? First is right to hold or possess the land solely or jointly, right to peacefully enjoy or use without causing injury to others, right to dictate use terms with tenant, sharecroppers, lessee, right to expel the unauthorized from premises, right to derive benefits, right to make improvements above and below the ground after obtaining required permission from appropriate government or departments, right of residual nature, right to alienate or sell temporary or permanent or full or partial land, right to inherit the rights, right to avert the exploitation of land, right to extract surface and subsurface minerals after obtaining required permission from the appropriate government. So all these are rights of the presumptive title holder. And what are the rights of the government on the private lands? Like, for example, right of royalty for minerals which are present subjacent to the land, right of resuming the land back to the government if the land is abandoned or cheated or used for any other purpose other than for which it was assigned on registry or leave, right of attaching the property if the dues to government was not paid in time, right of granting and rejecting permits and licenses if an activity other than original activity for which the land is assigned is undertaken at the assigned site, right of government on hidden items above or below, which is more than rupees 25, right on every tree for which the tree value is not paid by the assignee at the time of the assignment, right over royalty like tea, blackwood, ebony, sandalwood growing in private lands, right of entering the premise without permission for the purpose of survey and demarcation of adjoining lands. So these are the rights of the government on private lands. Now, what are the types of interest on land? Competing interest, overlapping interest, complementary interest, overriding interest. Efforts by NLRMP. Now you must be wondering what is NLRMP. NLRMP is National Land Record Modernization Program, which came into existence or launched in the year 2008 by the Government of India. And what was the purpose of this? The main purpose of this particular scheme or program was to digitalize and modernize land records and to develop a centralized land record system. So what are the efforts made by this particular program was the states failed to recognize the record of right as a valid document for providing right over land by making appropriate changes in the existing land related laws, bringing in a new law exclusively for the concerned state. That can also be done because of 7th schedule of Constitution of India. Another impediment was the issue connected with the Registration Act 1908, which does not impose production of ROR by the seller as a mandatory document for effecting registration of properties in the buyer's name. This could be done by Government of India as the same is a central act. Production of authenticated map sketches along with the documents for registration of properties have not been made mandatory through appropriate amendments in the Registration Act 1908. Hmm. Now, mutation or transfer of registry laws in various states does not provide any provision for bringing an automatic online mutation or transfer of registry subsequent to the registration of deeds as per the provisions of the Registration Act, and the lack of genuine land records and heterogeneity of the maintenance of management in various states due to lack of common standards another problem. These were the efforts and the problems faced by this particular program. Now, during my research, I thought I would come up with a land revenue administration by taking one state as an example. And I encountered some issues connected with land revenue administration of the state of Kerala. So, in the next video, I will discuss this particular state in totality with reference to land revenue administration. Um, Thank you so much. Please, I would continue the same topic or give the example of Kerala as a state with regard to land revenue administration. Uh, Thank you. Stay tuned, please.